Well, good morning, and welcome to the third installment of our 2024 Compliance Webinar Series, and our second webinar on 1071. My name is Brad Stumpe. I'm the practice leader for Bank Compliance and Loan Review Services at Anders. For this webinar, we're honored to be joined by Linda Ezuka from CRA Today. And welcome to Linda, to the CRA Today team, and to all of you across the country who are part of the CRA Today community. Well, thank you very much for joining us this morning. We're delighted to have you. For those of you who participated in the live webinar, we have re-recorded my portion to remove the echo, so this should be an easier listen. As advertised, we're not going to get into the nuts and bolts of the 1071 rule today. But if the demand is there, and I suspect it will be, we'll have another webinar that gets down into the weeds in the coming months. But today, we're going to talk more big picture implementation strategies. What to think about from a fair lending perspective, and then what to think about from a CRA perspective. I'll kick things off by quickly going over some of the basics along with implementation and fair lending considerations. I'll then hand it over to Linda to discuss the CRA implications of 1071. And finally, I'll be back to wrap things up at the end. A common question we receive at Anders revolves around the impact of the legal challenges to the rule. I think we all know that the Supreme Court ruling earlier this year effectively ended the stay, and we now have new compliance dates, which I'll get into in a minute. But I believe that Linda will get more into the details of the challenges during her presentation, but the chatter that we've been hearing is not optimistic. So I would not delay preparations, either waiting for the appeal to be resolved or in hopes that it will come down in the industry's favor. This is particularly true for those of you who are Tier 1 and even Tier 2 reporters. So currently, the only concrete impact of the legal challenges has been to push back the effective dates by 290 days, which is the length of time from the injunction to the Supreme Court ruling. So essentially, it bought everyone about 9.5 months. I'm not going to spend a lot of time on the tiers and how to figure out which tier you're in. We covered those in quite a bit of detail during our previous 1071 webinar. As an FYI, you can find a link to that earlier webinar on our website if you're interested, www.anderscpa.com. The number of originations hasn't changed as to what qualifies for the various tiers. Tier 1 continues to be the higher volume lenders, and they will be the first to begin collecting and reporting data, followed by tiers 2 and 3. This slide includes the origination level, along with the revised initial collection and reporting dates for Tier 1. But remember that if you want to do a dry run with your processes, you can begin collecting data up to 12 months prior to the collection date. So Tier 1 reporters could be collecting data now to test your procedures, processes, systems. Just be sure you're following the data collection rules when gathering ethnicity, race, sex, ownership status, and that includes the firewall rule, which we'll cover a little later this morning. This slide includes the origination level, along with the revised initial and collection and reporting dates for Tier 2. One thing I do want to point out is that with the extension of the effective dates, and this goes for all tiers, you can either use 2022 and 2023 as the 2 years to determine your tier, or you can use 23 and 24. So if you think that your originations were enough lower in 2024 as opposed to 2022 to move you to a lower tier with a later effective date, you may want to take advantage of that. Along those same lines, you may recall that one of the options to determine your number of annual originations was to annualize fourth quarter 2023 originations and apply that number to both 22 and 23. With the extended compliance dates, you now have the option to annualize fourth quarter 2024 originations and then apply that number to both 23 and 24. So this slide includes information for Tier 3 reporters, which have the latest compliance date. But continuing on with that last thought, if you're not squarely within one of the three tiers, you'll essentially want to look at 4 different options to see if it will move you down a tier and buy you a little more time. And those 4 options are: first, full year originations for 22 and 23; second, full year originations for 23 and 24; third, annualized originations for fourth quarter 2023; and finally, annualized originations for fourth quarter 2024. Whichever of those 4 methods puts you in the lowest tier is the one you'll want to use. Unless you're just chomping at the bit to get into 1071, which I don't think anyone is. So a quick reminder here that we're concerned with loan applications from businesses that had gross annual revenues of $5 million or less. Regardless of loan amount, if the business had GAR of $5 million or less during its preceding fiscal year, then we need to be thinking about 1071, which references the SBA's definition of a small business concern. So it's pretty broad, and it does, yes, include agricultural businesses, so farms, but does not include government entities or not-for-profit organizations. This slide includes common loan types that are covered. It's not an exhaustive list. So look back to Reg B, and the rule covers an extension of credit that is primarily for business, commercial, or agricultural purposes. So if it meets this very broad test and is not an excluded transaction, we'll get to those in a minute, then it's a covered transaction. To determine what tier you're in, we refer to these as covered originations, which is the title of the slide, since you only count originations to determine your tier level. When it comes to reporting, we refer to them as covered transactions, because it will also include applications that do not result in origination. So think denials and withdrawals. A common way to determine if a loan is primarily for a certain purpose is to look at the loan proceeds. If more than half of the proceeds are for business, commercial, or ag purposes, then it's a pretty safe bet to designate it as a business loan. In the past, we've run into situations where a tweener loan that should probably be documented as a consumer deal was instead documented as a commercial deal to avoid consumer disclosures, I think. My concern with 1071 is that we'll see the reverse of this. Something along the lines of, I don't want to tick Brad off by asking him all those sensitive questions. I just as soon deal with the consumer disclosures. So let's document it that way. Educate your people as to what is consumer and what is commercial, and then stress the importance to them of documenting the loan appropriately. So this slide lists those types of credit that are excluded from the tier count, and most of them are excluded from coverage altogether. So let's focus on the first couple of items. So reevaluations, extensions, modifications, and renewals. These are not counted to determine your tier status or whether you're a covered financial institution under any circumstances. And they're not reported unless new money is involved. But refinances are counted and are reported regardless of whether new money is involved. So what's the difference between reevaluations, extensions, modifications, renewals, and a refinance? A refinance is when the new obligation satisfies and replaces an existing obligation, which probably sounds familiar to some of you. If the agreement simply amends one or more terms of an existing obligation, and that existing obligation is not satisfied and replaced, then it's not a refinancing. So the takeaway here is that many of these terms are used interchangeably, and perhaps even differently throughout your bank. You need to sit down with all of your commercial lines, understand how these terms are used, and be sure everyone is familiar with the 1071 definitions and what will be reported versus not reported. So second bullet point, HMDA loans. You will not count HMDA loans to determine tier status, and you will not report HMDA transactions. If HMDA is a yes, then 1071 is a no. The takeaway here is to be sure everyone understands what a HMDA transaction is. Someone who is not familiar with the intricacies of these rules may think that a commercial loan that is secured by a dwelling should be on the HMDA LAR and thus not the 1071 LAR. but not all dwelling secured commercial loans are HMDA reportable. So understanding the interplay between 1071 and HMDA will be important. I mean, for those of you who will be 1071 reporters, but are not current HMDA reporters, it's time for you to learn enough about HMDA to effectively report your 1071 data. The next few slides will be an overview of the broad data fields that will be collected and reported. Again, no nuts and bolts, just a refresher so they're top of mind when we begin discussing implementation, fair lending, and CRA considerations. As we go through the data fields, you'll notice that some have an asterisk and others do not. Those data fields with an asterisk are the ones that are required by the Dodd-Frank Act. The data fields without an asterisk are those that were added at the CFPB's discretion, which the Dodd-Frank did allow. So circling back to our conversation about the legal challenges, and this isn't part of any of the challenges so far as I know, just a potential compromise as the industry searches for a practical and effective way of fulfilling its obligations. One of the things I could see happening is that with smaller reporters would submit a smaller data set that omits some or all of the fields without an asterisk, similar to what we see for HMDA. But that is purely Brad thinking out loud. And it's not anything that I've seen or heard from an official source. So it's probably one of those things I should keep to myself. My wife tells me that I have a lot of those. But anyway, from an implementation standpoint, one thing here that I want to discuss is the application date. Rhetorically, how many of you have a standard commercial application? When we're reviewing HMDA laws, we see application dates all over the place for commercial loans. For consumer purpose HMDA loans, you can generally fall back on some type of standard definition, maybe something that incorporates those 6 required elements under TRID, but there's no such rule for commercial apps. You'll want to sit down with all of your commercial lines, I know, again, and see if they have anything that might approach an application. If they do, take that and see how it might be modified for 1071 purposes. 1071 does not require a written application for commercial loans, but if you're not going to use one, give serious thought to how you're going to collect this data. The rule does require reporters to have procedures that are reasonably designed to collect applicant provided data. And again, rhetorically, without an application requesting this data, what do those reasonably designed procedures look like? As a side note, during one of our earlier webinars, one of the poll questions asked who was using a commercial app. And over half of the respondents indicated that they either were already using a commercial application or had near-term plans to do so. That number was a little bit higher than I expected to see. But back to the reasonably designed procedures, what exactly does that mean? If you look to the comments to section 107C as in Charlie, it states that the earlier in the application process the information is requested, the more likely it is that the timing will be considered reasonably. That comment goes on to say that under no circumstances may the initial request for applicant provided data occur simultaneous with or after notifying an applicant of the action taken. So earlier is definitely better. And the request also has to be promptly displayed or presented. So if the applicant is likely to overlook, not hear the request, or if the process discourages or obstructs an applicant from responding, then it probably would not be considered reasonably designed. Look to credit type and purpose at the bottom right of this slide. These are 2 fields that are applicant provided and each have 10 or more codes that can be reported. So your data collection procedures have to be reasonably designed to gather enough information to determine which of those codes is appropriate. All right, we've got several more data fields here. One of them that is considered applicant provided is the amount applied for. Couple this with the amount approved or originated, and someone could analyze whether applicants from certain groups or from certain geographic areas were approved on average, let's say for 60% of the amount requested versus 95% for another group. And then take that a step further. And is there a trend in the rate of withdrawn applications that may be related to the amount requested versus the amount approved? And what kind of path does that lead us down? So as you're probably starting to see, if you hadn't already, this information can be sliced and diced in a lot of different ways. Then look to reasons for denial at the top right-hand column. In addition to comparing denial rates for one group versus another, a user would also be able to see if there were any trends and why certain groups were denied. Well, that being said, as you browse through the data fields, you might notice that there isn't much in the way of underwriting data to show something along the lines of, well, applicant A in this particular industry using the NAICS code was denied due to collateral, but here are a dozen other applicants in the same industry with a higher LTV who received the same type of loan for a similar purpose. The only field to make that direct correlation to a denial reason is time in business. So that comes down to the public potentially seeing different denial rates for different groups, but not knowing the story behind each of those applications. Unlike with HMDA, where DTI, LTV, and credit scores are reported and can either help or hurt you, this is kind of like going to the pre-2018 HMDA days when disparate denial rates is all a user could see. So several of the fields on this slide were added at the CFPB's discretion, and many are considered to be applicant provided data, amount applied for, NAICS code, number of workers. So during the application process, you need to have procedures that are, say it with me this time, reasonably designed to collect sufficient information so that you can meet your reporting requirements. So this slide includes gross annual revenue, which is a DFA required field and is an applicant provided field. Probably one of the most important applicant provided fields, as whether you collect and report 1071 data hinges on the applicant's response to this question. So a couple of slides ago, we talked about earlier is better for those reasonably designed procedures. That's because the earlier in the process you request this data, the better the chance you have of collecting it. One thought may be to have a screening question very early in the process about whether gross annual revenues are 5 million or less. If the answer is yes, then you determine HMDA or not. If not HMDA, then you know that you're in 1071 mode and those procedures kick in. Other than time in business and gross annual revenue, this slide includes several fields about the interest rate, along with various charges and fees that were added at the discretion of the CFPB and that are not applicant provided. But between the pricing, fee, prepayment penalty data, a wide variety of pricing analyses could be performed. This slide includes a couple more pricing and terms fields that were added at the CFPB's discretion, and then comes the information that's causing all the stir. Asking commercial loan applicants the ethnicity, race, and sex of the principal owners. And for those of you who spend any time in BSA, this is similar to, but not exactly the same as, principal owners under beneficial ownership. We're still looking for at least a 25% interest, but you do not have to drill down through other entities that may have an ownership interest in the applicant to determine that 25%. You're just looking at the top line owners for this. The data collection procedures are similar to HMDA, but not exactly the same. One of the differences is that in a face-to-face application, if the applicant states that they do not wish to provide the information, that's what you mark down. Under HMDA, you need to make your best guess based on visual observation and surname, but you don't do that with 1071. Then you'll also be asking about ownership status. Is the business minority owned, women owned, or LGBTQI plus owned, which is a brand new ball game and adds a whole new component to the form that we're used to under HMDA. And I think the next slide should include a sample of the 1071 DI collection form. And here it is. I know that it's hard to see, but you'll notice that the right half of the disclosure is for the ethnicity, race, and sex of the principal owners, with all the aggregated, such as Hispanic or Asian, and disaggregated, Cuban, Asian Indian, categories that we're used to from HMDA. One difference here is that the sex gender field is free form instead of a checkbox. And with a 300 character limit, you will report the applicant's self identified sex or gender. On the bottom half of the left column includes business ownership status and the number of principal owners. Think about when in the process you will present this form or ask the applicant for this information. For DI with home loans, it's usually pretty early in the process. With the differences in the form, you can tell that your frontline staff, your online systems, however you are collecting this information, will need to make a preliminary decision about whether the application is subject to HMDA, 1071, or none of the above. I would not recommend waiting until the last minute to figure out how that will work best. This is another issue that you want to sit down with each of your commercial lines of business to discuss how this might work best for them. And then look to the standard disclosures at the top of the left-hand column. It has your typical language that the federal government requires us to ask you for this information, and we can't discriminate against you based on your answers. I'm not sure if you can read the second line in the third paragraph, but it says, our staff is not permitted to discourage you in any way from responding to these questions. The CFPB expands on this, stating that you cannot directly or indirectly discourage an applicant from responding. And then it goes on to say that communicating that the request is unimportant, encouraging the applicant to bypass the form, or otherwise attempting to influence or alter the applicant's response is considered discouragement. The 1071 rule also requires reporters to maintain procedures to identify and respond to indicators of potential discouragement. So externally, that could be comparing your response rates to those of similar reporters, which you won't have in year one if you're a tier one reporter. But if you're a member of any peer group, and I'm pretty sure that most, or at least a lot of you are, as year one progresses, you could discuss response rates amongst yourselves to at least give you an idea of where you stand. Internally, this could be comparing response rates by department, region, location, officer, whatever makes sense in your situation. Keep in mind that procedures to detect potential discouragement should be in place for all types of applicant-provided data, not just the data on this form. The last thing I want to point out on this slide is where you see the two arrows, and it says one or more employees involved in making a determination concerning your application may have access to the information provided on this form. So this disclosure only needs to be included if you take advantage of the feasibility exception in the firewall rule, which brings us to our next slide. Okay, so I forgot about this slide. But the firewall provision prohibits a bank employee or officer who is involved in making any determination concerning a covered application from accessing the ethnicity, race, and sex of the principal owners or the business ownership status. Making any determination means that you're involved in decisions about whether to make the loan or regarding the terms of the loan. And it includes making the decision, participating in the decision making, or recommending that a certain decision be made. The commentary and the compliance guide give several examples and would be a good starting place to gain some context. One example given is that if a scenario is run by the compliance officers to, hey, can we do this? And the response could impact the decision on the application, then the compliance officer was involved in making a determination. So as you're probably concluding, the firewall rule could cover a significant portion of your lending staff. But before you hit the panic button, there's something called the feasibility exception. The feasibility exception basically says it's okay for a particular officer or employee to have access to this information if it's not feasible to maintain a firewall for that particular individual because their job duties require them to collect, see, consider, refer to, or otherwise use demographic information or ownership status. So let's go ahead and advance the slide. Okay, here's the firewall slide. You're not required to hire additional staff, upgrade your systems, change your lending or operational processes, or revise your policies and procedures solely to limit who has access. And when determining who should have access to this information, you can take into consideration the size of your bank, the number of employees or officers at a particular location or within a certain line of business, the number of reportable applications you expect to receive, whatever makes sense in your situation. You can make this determination on an individual by individual basis or on a group by group basis. So if your commercial loan officers are involved in making a determination and are also who will be requesting and collecting this information, let's say that's who has historically done so for business purpose HMDA loans, then you can allow your commercial loan officers to have access. But just because you determined that one or more groups should have access to this information doesn't mean that everyone who is involved in making a determination can be allowed access. So maybe it makes sense to allow your commercial lending staff and processors, along with your loan compliance staff, to have access, but not your underwriters. And I'm not saying that underwriters can never have access, just not in this example. So if you end up making the determination that someone who is involved in making a determination needs to have access to this data, and my guess is that many of you will, then just be sure to include the notice on the data collection form. I would memorialize, and memorialize means document, how you came to these decisions and how firewalls are erected. So when your examiners or auditors ask, you can support your decisions so that you can revisit them periodically to see if they still make sense. All right, what are some considerations to be sure we have a solid game plan going into this? Once you figure out what tier you're in, work backwards and build a timeline by which you want to reach certain milestones to measure your progress. The second bullet point on this slide is discuss the issue with your staff early and often. Let them know it's coming. Share the data fields with your staff so they can start thinking about how best to gather the information. Then determine which of these data points you currently collect, at least most of the time. How do you collect them? Where are they stored? Which data points do you not currently collect, and how will you go about that, with or without an application? Think about who you want on your implementation team. Now, this will be different for everyone, but think about the compliance officer, chief credit officer, representatives from different commercial credit lines, different functions, so lenders, analysts, processors. If your current HMDA or CRA reporter, someone involved in that function. What about an advisory director that might provide more of a customer perspective? Give this some thought and get that team together. If you're a current HMDA or CRA reporter, whichever platform you use for those will likely have a 1071 platform. Talk to that provider about their timeline and how you can collect and store the data points to make the process run smoother. One of the primary purposes of the rule is to facilitate the enforcement of fair lending laws, and this data will be public. Give some thought to how that data might look to examiners, community groups, the media, all of who will have access to it. How will your denial rates and pricing look if it is segregated by the different demographic data that will be collected and the demographics of the census tracts reported for those applications? The next few slides will dive a little deeper into these issues. Okay, redlining considerations. An address from which you can derive census tract information is part of that applicant provided data for which you must have procedures that are reasonably designed to collect the information. From this, anyone can determine your level of applications from census tracts that have certain demographic characteristics. Off the top of our heads, we immediately think of majority minority census tracts. versus majority. Majority census tracts, but it can be more than that as well. Think also about withdrawn and incomplete applications. If a significantly higher percent of withdrawn and incomplete applications are from a certain group of census tracts, are borderline creditworthy businesses from one area receiving more assistance than those from another area. Then there's the application and action taken dates. Do you deny applications from certain areas quicker than you deny them from others? Does it take you significantly longer to close loans in some areas than in others? For the most part, even if you don't begin collecting demographic information ahead of your compliance date, you should have geographic information available for your commercial loans, and you can begin analyzing at least some of these scenarios before you begin collecting the data that you'll actually report. If you want to see whether there are areas that you want to look into. As we talked about, there are minimal underwriting factors on the small business loan register. There's gross annual revenues, time in business, and not much else. There is other information about the applicant, such as the NAICS code, number of workers, but that's more to be sure that they're comparing like businesses or apples to apples. While you report the reason for denial, such as credit characteristics, use of loan proceeds, cash flow, collateral, aggregate exposure, and so on, you're not reporting debt service coverage, loan to value, or other information that relates back to these reasons like you do for HMDA reporting. So from an underwriting perspective, it's mainly going to be comparing denial rates to businesses that have a different ownership status or principals with differing demographic characteristics. And this is always the headline statistics we see with HMDA data. This group had a denial rate of X versus another group with a denial rate of Y. The difficult part with 1071 will be that commercial loans as a whole are not nearly so standardized or homogeneous as your typical home loans. And communicating those nuances to whoever may be questioning a difference in denial rates is not going to be an easy task. But don't just assume you'll be okay with a simple explanation that, hey, no two commercial deals are alike. Take some time between now and when you begin collecting 1071 data to meet with your commercial lending staff. Discuss underwriting standards. Are there any differences between branch A and branch B? Are there any parts of our policy that we usually don't follow? Do exceptions to policy happen more frequently from certain sources? Under what scenarios are exceptions allowed? And does everyone have a similar understanding of those scenarios? Is there a mechanism in place to track exceptions? If not, should there be? If so, do we want to change anything about it? Do we want to add demographic information and business ownership status to that system? So a lot of things to think about from an underwriting standpoint. Okay, pricing considerations. Whereas we won't have a lot of information to go on to tell the story about underwriting, there'll be an abundance of information for pricing. The interest rate is just the beginning. The most rudimentary analysis would be that a certain group had an average rate or a median rate of X versus Y for another group. Oftentimes, when we're performing a pricing analysis on HMDA or consumer data, we'll compare the rate and fees to a bank's rate sheet and analyze deviances from the published rate and fees rather than an average or median rate. But I also know that there's less likely to be a rate sheet for commercial loans, but who knows if that's going to be changing as well. With 1071, not only will we have the rate, we'll also have the type of rate, and there are 7 different options to choose from there. We'll know how long that initial rate is in effect, what's the name and value of the index that the rate is based on, what margin is added to that index, and then what type of origination and broker fees were involved. In addition to this upfront information, you'll also be reporting the amount of any initial annual charges, whether the product is a type for which your bank sometimes charges a prepayment penalty, and then whether this particular loan included a prepayment penalty. So there's a lot of information that can be compared from one group to another to see if there's any difference between them and whether any of those differences appear to put one or more groups at a disadvantage. So this slide includes some other things to think about that don't fit neatly into the underwriting or pricing discussion. But that could be indicators of one group receiving more favorable treatment than another. So I believe we hit on the length of time from application to action taken, the amount applied for versus approved or originated as we were reviewing the data fields. The last two are pretty straightforward. If you look to loans from similar industries and for similar purposes, does one group generally receive shorter term loans than another group? If so, why is that? And does it seem to favor one set of borrowers over another? For guarantee type, there are 12 different options ranging from various government guarantees to the personal guarantees of owners and non-owners, an old Reg B issue. So the analysis here will be whether it looks like we're requiring certain types of guarantees more frequently for one type of borrower as compared to another. This final slide before I turn it over to Linda includes a few discussion items that you may want to throw out at your bank. You may want to add whether using a commercial loan app makes sense or what those reasonably designed procedures might look like. But a lot of it deals with risk and what level of risk your bank is comfortable with. The regulatory agencies acknowledge that relationship banking is a significant part of small business lending. Banking is all about managing risk, with judgment and discretion being significant factors in the equation. So the conversation should revolve around what type of controls can we put in place to mitigate the inherent risk that comes along with discretion. So with that, I believe I've reached my allotted time, so I'll hand it over to Linda to discuss the CRA implications of 1071.
Great. Thank you so much, Brad. Can you hear me okay?
I can hear you just fine, Linda.
Excellent. Excellent. So thank you so much, Brad. It's a pleasure to partner with you and the Anders team. Thank you so much for this opportunity. And it's so nice to see so many familiar names from our community development community, as well as my CRA Hub members. So welcome, welcome. Thrilled that you're here. For those of you that don't know me and we haven't met yet, I'm Linda Ezuka with CRA Today, and I help bankers master the CRA, get exam ready, and leverage capital for the greater good. I also have with me Alyssa Lumadou, and she's on my team, and she is in the Q&A section today to help with the rest of our session. And I'm just so passionate about the CRA, and I've been doing this for 30 years, and just it's such an honor to be able to partner with bankers across the nation to drive capital to disadvantaged communities and drive impact. So while we'll talk about compliance today, my end game and my hope for you is that we master the technical elements of compliance, but then we really drive capital and leverage capital for the greater good. So we are going to talk about CRA, the implications for 1071, just a few things that you might consider as we move forward. So we'll go into the next slide. Krista, thank you so much. Okay, so where are we now? It's been a journey, right? It's been a journey. So next slide. As you know, there's been lots of activities. Of course, we have an injunction. So we'll move to the next slide, which is a better slide that kind of shares where we've been and some concerns going forward. So as you know, we have the new rule as of October 2023, but there's been a lot of activity over time. I will say that our industry, like the ABA and ICBA and others, have done an excellent job of keeping all of us informed, right? And to help us really navigate where we are. So I'm grateful for their leadership there and helping us work through the future of the CRA and what might be. So this is just an account of some of the high level actions that have taken place. Of course, what we're anticipating that there may be some changes, of course, likely changes with the November election. So many things, many different paths are possible going forward. So the timing's really unknown, which makes this uncertain for us, right? But today I'm hoping to share a couple of items that you could focus on, things you can control, shore up your activities and some of your processes so that you're as prepared as possible. Oftentimes we're trying to figure out, do we stay the course? Do we anticipate and start to understand the new rule? And there's many different answers for everyone there. So certainly there's a political impact that's before us, but then we may have another year. So if you know how I roll, put in the chat, what is your estimate for when we might have some sort of clarity around this? So you just put your ideas in the chat. When do you estimate, if you had the crystal ball, when do you think this might be resolved? So never. Fall 2025. Any other guesses? 2027. Okay. Yes, they're coming in fast now. Yep, election certainly has something to do with it. 2026. Yes. So many things. We'll see. We can do a poll and maybe do some bets. Anyway, we'll move on to the next slide. We shall see where the timing ends. So in the meantime, we'll continue to serve our communities. I know that everyone on this call cares deeply about community development and the communities in which we serve. So that doesn't change, and we have a lot of work to do. So today we'll share a few things about where we're at and where we're going. So let's talk about kind of the framework. Of course, you've seen this. We all pretty much understand at least this baseline of where we might fall as an institution within this framework going forward. So let's talk about the next slide, though, about some of the elements that I recommend that you start to address. I suggest that you look at section by section, 12, 22, 42, just to kind of level set around the new rule. There's also a great discussion around section 1071 because the proposed rules, the final rules, all anticipated section 1071 coming into play, of course, right? And so it is anticipated that we'll have a transition period, right, where we are replacing some of our definitions around small business, small farm going forward, right? So I'm going to kind of compare and contrast how that might change based on what we know today, right? So since we are under the injunction, of course, there's still a lot of uncertainty. As most of us have skimmed, read, studied, restudied, right? The elements of the new rule, the more I read, I have so many more questions as it relates to implementation or the deeper questions that we have as things are outlined. So there is so much more that we will need to unpack, if you will, as an industry as we move forward and when we move forward. So there's a lot. So let's just look at the definitional shift here. So we have, of course, today, right, we're under the legacy rule, right, with how we define small business. Now looking to the new rule, we have two definitions from section 12 of the rule, and they have started to define what is a small business, right? And so that is aligned with section 1071. Small business means a business with gross annual revenue, right, for its preceding year of 5 million or less, right? However, we have a different definition right now in the new rule for a small business loan. Is the same way we look at that loan parameters as the current definitions, right? So it's a loan to a business based on loan amount, right, $1 million or less, and then call code definitions, 1E1, 1E2, 4A. right? And so this is setting us up for a transition, but we have some, we have a little bit of a difference here. So a good way of thinking of this is that, yes, they have aligned the definition of small business, but we are to remain focused on, well, what data, right? So right now, until we hear otherwise through a Federal Register notice, right, we are looking at small business loans as $1 million or less, right? And the call report definitions 1E1, 1E2, 4A. Okay. So now if we're looking post implementation and more guidance, right, from our regulatory agencies, the new rule says we anticipate 1071, right, in the narrative, right, but we will submit a Federal Register notice with more guidance, right? So until then, we stay on the left here in terms of how we define a small business loan. So it will change, though. If you think about how we define small business now, the pool is here. I see once we transition, the pool is greater because we're looking at, of course, eventually, regardless of loan amount, right? Small business entities or business entities with 5 million gross annual revenue or less. So the pool becomes larger, and there's still a lot that we don't know, right? We need a little bit of clarity, which I hope will be forthcoming when it's ready to be published in the Federal Register around renewals, right? Are we going to adopt the strict CFPB rules around excluding a nonprofit, if you will, right? Or a municipal loan? Or are we going to exclude renewals, right? Are there any other differences, right? Because that will change significantly. They are somewhat incongruent just at first blush, right? So we rely upon renewals right now, and we count them from a CRA perspective. So I'm curious, right, on renewals. And yes, there's some feedback, but specifically, I want very specific guidance on what would count and what would not, with examples, right? Because those devils are in the details. So we'll go to the next slide. Let's just talk about the things that we can control. So how should you prepare? Okay, so this slide, this is just a quick slide that you might want to adopt or adapt and provide in your training. This just shows where we're at today, how we define small businesses with a new rule until we move over how the CFPB defines small businesses, and then post, right, where there might be adjustments. So our commercial lenders and our bankers, we're really going to have to figure out, well, where are we and what rule are we trying to comply with, right? And what definitions then apply. Right. So there's a lot of training that is going to be before you, as you know. It's going to be quite the lift for all of you. And, I don't know about you, but sometimes we have a little bit of challenges really engaging our line, right? And helping them understand that compliance is a part of originating loans, right? And deriving revenue, right? And really building up that culture of compliance. And so that is going to be such a challenge, because today we have a hard time with that. Tomorrow, and depending on your tier and then our new rule, it's going to get even more complex. So may the force be with you all. I know it'll be a lot for all of us to navigate. Okay, so I want to make sure we're really, really clear in case there's some folks that are newer to the CRA. Let's go to the next slide. So it's well defined, but not always understood, how we collect small business loans today, in terms of loan amount, right, as it relates to classification in 1E1, 1E2, and 4A. Well, call report right? A call report is the current loans outstanding, right? But we, from a CRA perspective, we count loans at origination, right? So there's always a little bit of confusion. Are we looking at classification of CRA of small business loans, or are we looking at small business definitions as it relates to community development loans, right? But we'll stay focused on small business loans as it relates to CRA performance today. So just wanted to, if you want to study a little bit more, you could pull out those call report instructions and get clear for your bank on are we doing this part right? Have we revisited certain extracts that we have, and are we really honing in on capturing all the loans that count? So let's go to the next slide. Okay, so this is, I just want to recommend that we start to collect actual GAR. So in the chat, I'd like to hear, I'd like to see if you are collecting GAR or gross annual revenue GAR indicator codes from the line or from your documentation specialist. Put it in the chat. Are you collecting indicator codes? Meaning, are you importing indicator codes into your CRA software, or are you bringing in GAR and then it becomes a derived field? So some folks are bringing in codes and they're like, I might want to revisit that, right? Because at some point, someone within the institution needs to make sure that they are accurately identifying the indicator codes. And is that the line, or is that you, or is it a derived field? I recommend that we all actually collect GAR. Okay, so the indicator codes may be changing, right? We will wait for guidance, but the new rule, of course, wants to see, are you truly serving the smallest of the small businesses, right? And so now we're going to be collecting GAR and looking at under 250 gross annual revenue, right? So new sorts. So going forward, we'll need to figure out, the transitions to that, right? And so we're going to be looking at bigger pools and finer sorts. We'll move to the next slide. Okay, so this is a current table that we look at now. Are we serving corporate America? It answers that question. Or are we serving the smallest businesses in our communities? Now, with the new rule, we will have a finer sort to this, right? Not just under $1 million, but the very small businesses within our communities. So that will matter, and we need to collect GAR appropriately. So now I'm going to shift into just really making sure that we are clear on focusing on gross annual revenue. If nothing else, let's really take a deep dive into this and triple check our practices. So don't import those indicator codes, or really make sure that 1, your line understands the definitions, 2, they are applying the principles, 3, you're training them, 4, you have 3 lines of defense and you're checking accuracy, right? Because at the end of the day, we have to make sure that those indicator codes can withstand examiner scrutiny in a data integrity exam. So I would recommend not importing them, but if you are sure from a process standpoint with your line, then you may. I recommend that we do not, so that we're in the practice of identifying gross annual revenue based on what regulatory provision we are complying with at the time. Okay, next slide. Okay, so I've mentioned this, but we'll be looking at this today, right? But this is gross annual revenue is the thorn in our side and the most common data integrity error that we have in the CRA. Now, we're not quite getting it 100% right today. Tomorrow, there'll be more rigor, right? And we'll need to make sure we get it right. So training is so key today to make sure that we are moving forward with integrity and we have solid data. So next slide, please. Okay, so this is just a check. You may be rock solid, but you'll want to revisit your training. You have turnover, you have teams. Really recognize that it's not necessarily what the underwriters use to sensitize the revenue of the business to make their credit decision, but we're taking the top line revenue, as many of you know, right? But just to really make sure we understand that and look at your training, we'll go to the next revenue. I'm preaching to the choir. I know you know a lot of this, but I just want to make sure that we're going back and rethinking, do we have that covered? Have we checked that recently? You can go to the next slide. Okay, so startup entities, we still have some confusion around that. We never take projections, right? So does the line understand that? Are you capturing the right data? And what is your source document? What is your source document to secure this, right? To this field for data integrity purposes. So just some key points to remind yourself and to triple check within your institution. We'll go to the next slide. Oh my gosh, time flies when we're having fun. This is the most important part. If you're multitasking, come back to us. Let's talk about data integrity controls, your 3 lines of defense. Now, I don't know about you, but I've speak to many bankers across the nation, and on HMDA, we're pretty clear. We have good CMS, we have a lot of expertise, we have first line, second line, and third line. While on the small business loans, we tend to soften a bit here only from a resource standpoint. Some of us don't really have the participation of our line, and our lenders and our lending documentation specialists, right? That they do 100% review, or that they feel like they're responsible for the first line. So sometimes we only have 2, which is okay. It is a resource concern, but of course the best practice is there a way we can move the culture of compliance, right, upstream, so that CRA is not done by one, right? That we have more risk management and more help on the 3 lines of defense. So we'll go to the next slide. So here's just some thoughts that if there's an aha here, if you want to go revisit some of these elements within your institution, just to get ready to focus on things that you can control and to perfect, I've not seen a perfect bank, but to perfect your policies, procedures, and practices and training. So do you have written procedures, not only for CRA data collection and maintenance and reporting, but do the lines of businesses have desktop procedures? Do they have that written? Like for documentation, how do they differentiate on the gross annual revenue? Is there a field of information, right? And this is just fine print, of course, but is there a way that you can shore up your written policies and procedures around data integrity? Next slide. I know we're at time, but I'm just going to indulge a few more minutes of your time. And if you have to hop off, we understand. We'll keep recording, and this recording will also be available to you. Okay, so the other checkpoint for you is, have you revisited how you show proof or how you validate your gross annual revenue? Right? What will you use as proof when in a data integrity review? Right? So you determine gross annual revenue in the indicator code during data integrity. What document will then the regulator check? You need to figure out what this is for your bank and document it, right? So maybe you're newer to the bank, maybe you're newer to CRA. Where is this document, right? Where is this? And by the way, we're going to have to differentiate between how we do this for CRA and then how we do it, of course, for 1071, right? So we're going to have yet another set of procedures. Okay, next slide, please. This is a piece that is often overlooked. You arrive at your bank, you're excited, you're leading your CRA program, and you get extracts on a monthly, quarterly, semi-annual basis, let's say. And then you work the extracts and you're capturing small business loans, right? And maybe we haven't paused to recheck that, right? Recheck the logic that exports from our core systems. Did core systems change? Did people change, right? Do we have more products? Do we have less products, right? So have we revisited our key extracts from core systems to make sure that we're collecting all of the applicable small business loans, proper call codes, right? And then that we're importing it well and have procedures to import accurate data, right? So really taking a deeper dive into these details, seeing if we can improve processes and embed more rigor into our CMS. Next slide. So this you may have seen if you've been in some of my trainings, but this is a simplified version of the end-to-end process of originating a small business loan. It begins with the intent to apply for a loan all the way down to it is in your database, the data elements are clear, and you're ready for your exam. Well, there are so many points along the way that you need to revisit and really identify control points, who's responsible, have not only control point identified, who's responsible, accountable, and that there's procedures in place. And identify, is there a person inputting or is it a flow of data, right? Control points along the way. If you ever have a data integrity issue, it's incredibly painful to go back through to look for the root cause. So I'd highly suggest that you just revisit this. And this is going to be different for a commercial loan that's underwritten, right? Versus maybe a small business loan that might even be credit scored, right? So you have different loan channels, processes that flow into our small business data. Okay, next slide. I know you know all this, but sometimes you may, if you're seasoned, you may be yes, 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 yes. But have you revisited? Have you stopped to reflect? Have we done enough training? Do we have everything documented? Do we need to revisit, right? So look at those core systems, develop the strategy, and make sure that we're able to look at our core systems and reconcile. Next slide. Last slide, just super high level. Hopefully you had a couple of aha moments, and you have an element that you're going to go revisit and reevaluate. But certainly GAR, I hope that you'll look at GAR, double up on your efforts on GAR, because it matters today that we get it right. It's like, let's shore it up now. If you're in tier 2, tier 3, let's get GAR right. Right? And let's really start to look at that, not only for CRA, but of course for the future of Section 1071. But it'll serve you well to shore up all of these systems in CMS. You may not have a user-defined field right around this, or you may, but you might want to find a way to make that better or have more instructions through the data flow. The train again, revisit training, have these training micro moments, right? And clearly communicate with small business customers, as you all know, will become more of a challenge going forward. Okay, I know I went over. I tend to get a little excited and go into the details. We have the Q&A open, but we'll go to the next slide. Here's where I am. I love CRA, happy to talk CRA with you, and I'm here for the industry for the long haul. This is my passion, and I just love to help bankers as we navigate driving impact to our communities, as well as navigating regulatory change. So thank you for your time today. I hope you have at least one aha, something to go revisit and level up in your institution. Brad, I'll let you wrap us up.
All right, thank you very much, Linda. That was great information. It's obvious that you have a love for CRA and for the banking community. Just to wrap things up real quick, this slide includes links to several documents that the CFPB has already issued that we have found useful. A couple to point out are the executive summary. It's not short, but could be a good place to start with senior management to give them a flavor of what to expect. I'd also like to point out the small entity compliance guide, which does a pretty good job of explaining the rule in, if not plain English, then at least simplified English. And that pretty much brings us to the end of our prepared comments. Well, thanks to everyone for taking an hour out of your day to spend it with us. A recording of this session will be emailed out to everyone who registered, so look for that in the coming days. Closing thought. Over the last couple of decades, we've successfully implemented an explosion of BSA rules and expectations, ATR and QM, TRID, loan servicing, a complete overhaul of HMDA. We even made it through PPP, and you're going to do the same with 1071. It won't be easy, but you can do it. On behalf of everyone at Anders, we'd like to once again express our gratitude to Linda and her team at CRA Today for joining us this morning. Our contact information is included here. Please feel free to reach out with questions on 1071 or anything else related to compliance. We have an experienced staff that consists primarily of former bankers and former bank examiners that are dedicated to loan compliance, BSA, deposit ops compliance, ACH, ALM, even outsourced loan review from a safety and soundness perspective. Thank you again for joining us, and have a wonderful afternoon.